Good morning, everyone, and welcome to the Senate chamber here at Capitol Hill, Saipan. As indicated, it's already 10 o'clock in my watch, and would like to resume the Senate impeachment hearing, which went on recess on Friday the 13th at 2, or right before 2. And during that, before we took the recess, there was a presentation by the impeached officials, representative, of which they've if my record or my mind or my recollection serves me right, there's two more on the agenda. But before I ask the impeach officials to come up to the witness stand, the chair would like to call for a short recess. Okay, so yeah, short recess. Okay, we're resuming our Senate impeachment hearing. And Sarge, I ask that you call on the impeached officials representative and have them situated on their seats. And again, for the record and for the viewing public, this is a continuation of the recess of the hearing last Friday. This is a recess from the hearing last Friday. And we are going to ask everybody to turn off their cell phone if you're in the gallery. And also, please know that we have a live feed on channel 24, I believe, and also on our legislative web Facebook Live. So, members, are you guys ready? Okay, with that, at this time, Council, just for consistency, we left off with addressing 4 of the 6, I believe. I don't know in which chronological order we did, but please continue on with your presentation. And please kindly advise the chamber if you have witnesses that are appearing somewhere else that are not presently here. And it is allowed, and it's know that you submitted that request in time. So go ahead. I recognize counsel for the impeached official.
Thank you, Mr. President, and good morning, Senators. Once again, I'm Anthony Uggan on behalf of Governor Ralph De Leon Guerrero Torres, along with my co-counsel, Mr. Gilbert Burnbridge. And yes, we have 2 more articles to discuss today. We'd like to begin with Article 6, who we have Mr. Ross Garber, who is appearing through video conference. One moment, Ross. There we go.
Article 6, which involves legal issues as opposed to factual issues. And this is the article that's based on the subpoena that was issued by the JGO committee to the governor. This was a subpoena commanding the governor to appear at a particular time and place and answer whatever questions the JGO committee had about the issues that they were reportedly looking into, and stay there for as long as the JGO committee wanted. It's an extraordinary subpoena. And there are several reasons why Article 6, as a matter of law, has to fail. First is that the subpoena violated the Constitution. I'm going to talk a little bit about that, about the separation and balance of powers in the CNMI Constitution. The second is that the subpoena violated the CNMI statutes. I'm going to talk a bit about that. Third is that noncompliance with a subpoena is not an impeachable offense. And fourth is that the governor responded reasonably to the subpoena. So starting off with the CNMI Constitution, the Constitution provides for 3 separate and co-equal branches of government. The legislative branch and the executive branch are separate. The legislative branch and the executive branch are co-equal. In other words, governor, the head of the executive branch, is not the boss of the legislative branch. The legislative branch is not the boss of the executive branch. These branches exist separately and co-equally. It's in some ways the genius of the kind of constitution that the CNMI and the federal government and the governments of the states have, this balance of powers and separation of powers. So, then there's this subpoena that was issued by the JGO to the head of the executive branch, the governor, commanding him, the legislative branch, or a committee of the legislative branch, commanding the governor to do something, to appear before them and sit there and answer their questions. Well, this issue has come up on the federal level, and our Department of Justice on the federal level has opined on it many, many times and it has said repeatedly that the legislative branch can't do because of this balance and separation of powers. The legislative branch can't subpoena the chief executive. In other words, Congress can't subpoena the president, and the Department of Justice has even said they also can't subpoena their senior advisors because those are alter egos of the chief executive. And this is over many, many, many opinions. This is not one or two opinions. It's many, many opinions. They've been issued for decades. The Department of Justice has been consistent about this. And it's one of these rare things that's been the same under Republican and Democratic administrations, that the separation and balance of powers means that the legislative branch cannot subpoena the head of the executive branch or his senior aides. Now, the AGO committee in the House have identified no precedent for the subpoena. And I will tell you, I've handled subpoena issues for Congress, for many other jurisdictions. I teach a class at Tulane Law School on political investigations and impeachments, and I'm not aware of any precedent, any place for a subpoena like this. And again, the JGO committee didn't identify any precedent. Instead, the JGO committee identified a couple of cases. They identified this case in Connecticut in which I happen to be involved, which is completely inapplicable to this situation. That was a case where an impeachment committee issued a subpoena to the governor, but also said they would do nothing to enforce that subpoena. And so on that basis, the court didn't invalidate the subpoena, but that's a very different situation than exists here. This JGO wasn't conducting an impeachment investigation, and they did not say they wouldn't enforce the subpoena. To the contrary, they said that they did intend to enforce the subpoena. And in fact, after that Connecticut case, a subsequent Connecticut court, faced with a legislative subpoena to the Chief Justice of that state, said just what I'm saying, said clearly, no, you can't do that. That Connecticut case was limited to an impeachment inquiry, and it was a situation where there was a pledge not to enforce the subpoena. So that situation is very different from this. And then the JGO committee cited two lower federal court cases, neither of which were to the chief executive. They were to actually former staff of the chief executive. And those cases actually settled before they were appealed anyway. Again, very different situations. We repeatedly asked the JGO to identify any precedent for this subpoena, and all they pointed to were these inapplicable cases. So for that reason, the subpoena was not a valid subpoena under the CNMI Constitution, and so the article on which it was based has to fail. But there's a whole other reason why that subpoena is not valid, and that's CNMI statutory law. Under 1 CMC 1301B, it provides that every investigating committee, when authorized by either house or both houses, as the case may be, may issue by majority vote of all its members subpoenas requiring the attendance of witnesses and subpoenas ducis tecum requiring the production of books, records, or other evidence. And here's the key phrase: in any matter pending before the committee. That's what authorizes the subpoena here. This subpoena was actually not authorized by in any matter pending before the JGO committee. Under the House rules, the JGO is permitted to consider and report on all bills, resolutions, and other matters referred to it by the House. And here, there was no referral by the House. There was purportedly a referral by the Speaker, but that is different than what is required under statute. And there's a case, again, Murphy versus Collins in Illinois, which dealt with a similar situation where there was not a referral by the full House. In that case, found the subpoena there invalid. And so for this separate reason, the statutory reason, the subpoena that the JGO committee issued was invalid. And so the article on which it was based is is not applicable. So there's a third reason why Article 6 has to fail, and that is that noncompliance with a subpoena is not an impeachable offense. The question before the Senate isn't specifically about the subpoena. It's broader than that. It's about even if the governor didn't comply with a valid subpoena, and again, for the reasons I explained, the subpoena is not valid, but even if it were, that's not an impeachable offense. Under the Constitution, impeachment is available only for treason, commission of a felony, corruption, or neglect of duty. Nobody's arguing that failure to comply with a subpoena is treason or felony or corruption. And there's no gubernatorial duty in the Constitution, statute, regulation, any place. There's no gubernatorial duty to comply with a subpoena. I think the House would have the Senate read this constitutional provision to say that any violation of any law by any potentially impeachable official is an impeachable offense. And that just doesn't make sense as a reading of the Constitution. So there's no gubernatorial duty. So Article 6 fails because the subpoena wasn't valid, and because it's not an impeachable offense. But it's worth noting that the governor responded entirely reasonably to this subpoena. He didn't just disregard it. He didn't just not show up. Instead, his counsel wrote a detailed letter to the JGO explaining the law and offering to negotiate and accommodate, and essentially saying, look, if there's information that you believe you're entitled to and that you think the governor has, let's figure out a way to get it to you without this subpoena process. And the JGO refused to engage in that process, refused to negotiate and accommodate, which again is very unusual. And here the governor actually even went that next step. And to the extent there was any ambiguity about the validity of the subpoena, he went to court. He asked the judicial branch to take a look at this and review the issue. So the governor acted entirely reasonably. So, here Article 6 fails because the subpoena violated the Constitution. It breached the separation and balance of powers. It violated the CNMI statutes. Non-compliance with the subpoena is not an impeachable offense, and here the governor acted entirely reasonably. And with that, I'm happy to answer any questions about these legal issues.
Thank you, Mr. Garber. Counsel, you still have do you want to add in?
That's the presentation, Mr. President. If you'd like to ask him any questions, he's available to answer
Do you
for
have any-
Article 6.
Do you have any witness to call for this?
This was our only person for today.
Okay, so now I want to open the floor for any of the members to place their question to the presentation, limited to that presentation. And again, it applies the same thing. Chair would read out your line of questioning to the gentleman. Council, who's controlling the slide? Are you the one doing it?
No, that's me.
Mr. Garber, is there a way you can go back to the like towards the beginning? I think it's the third slide, the one that you're referencing case laws that
Yes.
similar to this particular scenario. Yeah, this one right here. Can you review one more time what you've in reference to the questions before us? Can you reiterate or clarify further as to the similarities to the point that you're trying to make to this body?
Yeah, I'm happy to. So this is based on this separation and balance of powers. So this balance between the executive branch and the legislative branch. Neither branch is the boss of another branch. And that's what the U.S. Department of Justice has said repeatedly when faced with the question of if the legislative branch can subpoena the chief executive, can Congress subpoena the president? And they've repeatedly said, no, you can't do that because that disrupts the separation and balance of powers. So the case law that the committee cited was this one case from Connecticut, and in that case, it was an impeachment inquiry that was being done by a House Select Committee, where the House Select Committee had said, we're not going to do anything at all to enforce this subpoena. And so the question was, in that situation, was the subpoena null and void? Was it invalid? And there, the court said no, but because it was an impeachment inquiry, and here that's not the case, and because the House said they wouldn't do anything to enforce it. And if the House actually threatened the governor with arrest, threatened the governor with referral of criminal prosecution. It's a very different case. And you can see why that actually makes a difference in terms of the separation and balance of powers. And as I mentioned, the subsequent court actually reiterated that notion that the Connecticut case was limited to an impeachment inquiry where they weren't going to do anything to enforce the subpoena. And then there were these two lower federal court decisions involving former staffers to a president. And that's obviously a very different situation. Former staffer to the chief executive is very different than the chief executive himself. And so that's very different. And for what it's worth, those two lower court cases were never appealed. They were actually settled before they could be appealed.
Okay, thank you for clarifying that. I have one here from Senator Hokuk. Just to affirm, it's correct that the JGO subpoena is then correct that the JGO subpoena violated not only the law but thus far the CNMI Constitution.
Yeah, yes, that's what this presentation means. A subpoena command by a committee of one house of the legislature commanding the chief executive. Imagine if every legislative committee could command the governor to come and sit before it whenever it wants, for as long as it wants, stay there and answer every question it wants. That would disrupt the separation and balance of powers, and that's why it violates the Constitution. Yes.
Thank you. So, just for comparison, can you articulate between a subpoena, and I think I know this answer, but I just want it for the viewing public, and asking for a meeting, requesting for a meeting to discuss a matter?
Yes. Yeah. There were repeated overtures to have substantive discussions with the JGO about how, if they were looking for information that they thought the governor had, how is it, how could we figure out a way to get them that information without having this unconstitutional subpoena? And it's a situation I've faced lots of times. There are lots of different ways of doing it. And here the JGO committee just would not engage in that kind of process.
Thank you. Any other member wish to pose a question? Got one more question?
And Mr. President,
Yes.
yeah, and just to clarify, in interacting with the JGO committee, they had proposed some minor suggestions about how maybe we could switch the time that he would come before the committee and testify. But in terms of kind of a legitimate fix to the issue, they would not engage substantively on that.
Okay, why would we be in the know of this one? Why would we mention this in this platform? In other words,
What was that question?
Why would the members of the Senate want to know that particular statement that you just made?
Oh, I just wanted to make sure that I wasn't saying that we had no communication with the JGO. I want to be very, very clear about that. It's communication. What there wasn't was a collaborative process to try to get them the information they were looking for. They would not engage in that.
Understood. Thank you. Thank you for clarification.
Sure.
There's another question from Senator Hokuk. What's the difference or clarification between investigating expenditure versus investigating issues for an impeachment action? I'm going to repeat again. What's the difference or clarification between investigating issues for, okay, let me repeat it again. What's the difference or clarification between investigating expenditure versus investigating issues for an impeachment action?
Yeah. Okay. I think I know where the senator is going on this. So the reason that makes a difference is because if let's say this subpoena were issued in connection with an authorized, House authorized impeachment inquiry, and the House had pledged not to enforce the subpoena, sort of similar to the Connecticut case. I think what the senator is asking is, why is that different? And the reason that that's different, according to that Connecticut court, and before that, the issue had just never come up. And I'm not sure other courts would even authorize that. But I think according to the Connecticut court, what they were saying is an impeachment inquiry that's authorized by the House, it actually does, in its own way, tip the separation and balance of powers. So that in that situation, the legislative body might have more power than it otherwise does. But again, that's not the case here. Here, this was a regular House inquiry, and so that situation doesn't apply. The normal separation and balance of powers is the real test here.
Thank you. Any other? No further questions. Thank you, Mr. Garber, for joining us this morning here in the CNMA, and I believe afternoon somewhere there.
Thank you for allowing me to appear before you.
Okay, thank you so much. And there being no further questions to this particular article of the resolution, the chair would like to move to the next article, in which I'm going to allow the mic back to Council.
Thank you, Mr. President.
Again.
And thank you, Mr. Garber. May he be excused, Mr. President?
And he may be excused, yes. Thank you so much.
Thank you. To address the last article, Article 4, misuse of government resources, we would like to call our next witness, Mr. Joseph T. Lefoifoy, to the stand. Mr. Lefoifoy is actually in Honolulu, Hawaii, so he is appearing through video conference. Good morning, Mr. Lefoifoy.
Good morning.
Can you hear us loud and clear?
Yes, I can hear you loud and clear.
Okay, before we proceed, Council, I want to just clarify something with councils, legal councils. Thank you. Okay, at this time, before I return the mic back to the representative for the impeached official, I will recognize the clerk to administer the oath for the first witness. And at which time I'm going to ask, Mr. Lefoifoy, please stand and raise your right hand.
Please state your name. I
Joseph
do solemnly swear
solemnly swear
that the testimony I shall give is the truth,
that the testimony that I'll give is the truth
the whole truth, and nothing but the truth.
and nothing but the truth.
Jesus Masi, Mr. Lefoy. This time I turn the mic over to Council Agun.
Thank you, Mr. President. Okay, once again, good morning from the CNMI. Can you please state
Good
your
morning.
name? Can you please state your name for the record?
Joseph Lefoy,
Okay. Mr. Lefoy, what is your current occupation?
I am the administrative for the CNMI Honolulu Medical.
Mr. President, he seems to be cutting in and out. Is that okay with you, or?
No.
Okay.
I want to ask the IT, what can we do to resolve that? Okay, may I ask if your witness is using his phone? Is it
I believe so.
okay? So I guess we're gonna have to navigate slowly, and if we need to repeat, I'm going to ask that he repeat because it's true. Sometimes he gets cut off, and for the purpose of consistency and for the viewing public, we want to make sure that we hear him clearly. But
Yes.
I don't know what the answer to. I don't know if it's Hawaii Wi-Fi or CNMI Wi-Fi. I would like to say it's Hawaii's, but go right ahead. Again, if it's necessary, you can hear it. Ask him to repeat if it's necessary.
Okay,
Again, if it's cut.
understand. Okay, so can you just please state your current occupation one more time for the record?
I'm the administrative officer for the CNMI Honolulu Medical Referral.
Just to confirm, for the CNMI Honolulu Medical Referral Office, correct?
That is correct.
How long have you been with that office?
9 years.
Okay. Mr. Lefoy, what does the Medical Referral Office in Honolulu do?
A referral, which I'm sure a lot are familiar with, is a program that refers our patients from
I'm
Not
sorry,
yet.
Mr. Lefoy, but you seem to be breaking up. If you can just slow down, maybe, and yeah, you're cutting off every other word.
Okay. Basically, our satellite is here in Honolulu, handles the day-to-day logistics for the patients that are here, as well as those to the U.S. mainland.
Also, let me ask this. Maybe he should just remove the visual and just hear the
That sounds
the
good.
audio.
Yes.
Maybe
we
that
try
would
that?
help.
Okay. Little technical difficulties. Let's ask that question
Okay.
one more time to test. Okay, Mr. Lefoy? What does the Medical
Sure.
Referral Office do?
So our satellite office here in Honolulu basically handles the day-to-day logistics for those patients, as well as those that are referred to the U.S. mainland.
And do you have any other staff over there in Hawaii?
Yes, there are 5 of us, myself.
And you mentioned what areas your office serves. Can you repeat that one more time?
So our office serves Los Angeles and the surrounding area, as well as San Diego and the surrounding area.
Okay. And so to be clear, you do deal with different time zones in Hawaii.
That is correct.
I want to turn your attention to the year 2016. Did you ever meet with Governor Torres on around April of that year in Hawaii?
Yes, I did meet with Governor Torres 6 years ago.
And what was the purpose of your meeting with him?
So we prearranged meet at Best Buy so that we select the laptop, other electronic items that I had requested for our office.
Okay, so you requested previously for some equipment from your office, and he agreed to meet with you at a Best Buy in Hawaii, correct?
That is correct.
I'm just paraphrasing in case because it's a little choppy still. Why did you choose Best Buy?
I chose Best Buy because the wide laptops, uh, the low prices, and the after purchase maintenance and repair service they offer.
Okay. And when you got to Best Buy, did the governor in fact purchase that equipment?
Yes, so we pretty much proceeded to select items, the laptops, the software for the laptops, the Bluetooth earpieces, and then after selecting those items, went ahead and purchased.
Did the medical referral office in Hawaii purchase those items?
Oh no, we did not purchase. First was the one that purchased them.
And you saw him make that purchase?
Oh yes, I was with him when he purchased using a card.
Okay. Mr. Lefoifo, you should have with you what has been pre-marked as Exhibit J. I'm going to refer to Exhibit J2 specifically. Can you please tell me what is on that page, J2?
Uh,
Exhibit
that
J2.
is marked evidence list. Is it the one with laptop?
Yes.
So these are the three laptops that I purchased 6 years ago, including the mouse, the wireless Bluetooth, and some softwares.
Well, where were these pictures taken? Do you know?
Yeah. So I took this picture, submitted it. I took it right here in our.
So all that equipment is still with the medical referral office today,
Yes, that is correct.
and it's still being used today?
Yes. You utilize the laptops
Okay.
and and the um and the mouse.
Can you tell me why the laptops are important for the medical referral office?
So prior to having the laptop, we were not able to work. It now has given us the ability to work remotely, and it had been very essential during the time I had no choice but to work from home during the pandemic. Uh, so in that we have to come to the office, so any person that need our attention.
Okay. Can you please repeat that, Mr. Lefoifo? You were really breaking up to that question. Can you repeat what is the importance of the laptops to the medical referral office?
It was very essential to the medical referral office for us to be able to access remotely to our files that's needed for urgent matters.
And this also helped during the pandemic, correct? It allowed you to work remotely.
What I had stated was that it was um, it was a big help when we had no choice but to work from home, and we were able to access from home.
What about the Bluetooth headsets? Could you please explain those?
So the Bluetooth are that allows us to communicate safely while we are transporting. Here in Hawaii, it is against the law to be in your handheld while you're driving.
So it helped you to communicate with your drivers and not break the law, correct?
Correct, and not only for our communicate, the patients do call the drivers as well to notify done. So it's for both us and the
Okay. Mr. President, at this time, I'd like to offer Exhibit J into evidence. I'm just going to ask a few more questions, Mr. Lefoy. Thank you for your patience. We're dealing with a little technical difficulties, but please tell me if you can't hear my questions, okay? Yeah. Do you think that the electronics and equipment that Governor purchased for the medical referral office helped you and your staff to achieve its goals?
Oh, yes. Yeah, from date that it purchased 8 years ago all the way to now, you continue to use the laptop. So, yes, to answer your question, yes, it did help to achieve our goals.
And in your opinion, would you call the equipment that Governor Torres purchased a misuse of government funds?
Oh, no, not at all.
Okay, thank you, Mr. Lefoy. No further questions at this time.
Thank you.
Mr. Lefoy, if the Senate is now going to ask you some questions if they have any. Okay, please stick around.
Okay.
Okay, thank you, Council. Thank you, Joe. I do have a couple of questions here. This question is being asked by Senator Carl King Neighbors. Were you the one that made the request to the governor for the equipment?
So the governor initiated our request by asking me what can we do to our office, or what do we need to be able to work better for our op. So at that particular moment, the laptop was what we needed, and I can say we are very grateful that followed through and purchased the items.
Okay, so just for clarification on your answer, there was a recommendation or offer by, in this case, by the governor, and which you did not. You see the need for it. That's why you endorsed it. You said yes, we need it.
That is correct, Mr. President.
Okay. The subsequent question here has, I think, been made. Okay, so here's another question by Senator Hokuk. Does the Honolulu office, meaning the office that you oversee there in Hawaii, have credit card to purchase office equipment and other urgent matters, or the function of the office?
The answer is no, we do not have credit cards.
Okay, I'm gonna ask. I'm gonna kind of, just for consistency. So, do you follow procurement regs for purchase in state in your office? You say, for example, if we are to go through the normal procurement of those laptops that we're discussing, what would be the timetable for you to get that?
So
What's
our
what's the
satellite,
procedure? No.
okay, our satellite office here, we have what is called an Empress account. We are authorized to make payments for operational, the medical stipends and other authorized billings, medical billings. Other than that, anything else needed that is needed needs to be requested for to our director. And when we get the approval, we are able to use our checks to purchase the equipment.
Okay, so what's the typical time frame with regards to that?
Uh, I can't give you a specific time frame. Yeah, from a week to a month, depending on uh, what we're requesting for. Not all of them are authorized and approved.
Okay, thank you for that. Okay, here's another question from Senator Hukuk. Whose credit card was used to purchase this electronic equipment? Again, this electronic equipment is referencing the exhibit that is in discussion.
I can't answer the the direct question of whose credit card. I was there without a credit card and payment and signed for that payment.
Can you please repeat that again slowly?
I can't not answer to credit card was it that he used, but I was there when he made the payment with the credit card and signed for it.
Okay, thank you. Any other questions from Senator? Okay, Mr. Lefoyfoy, you mentioned earlier that you also manage um, the two other medical facilities outside other than Hawaii. Can you clarify which state is that or city?
So we do also have patients that are referred to Los Angeles, Good Samaritan Hospital, and that area around Los Angeles. And we have children patients as well as adults that are referred to. So those are the other two areas.
Okay. So I'm gonna stick with this particular issue. I don't have any particular questions in regards to this matter. I'll yield back to Council Agun.
If I may just have a follow-up question, Mr. President. Okay. Mr. Lefoyfoy, just we mentioned about the other offices that you deal with. So would you say that the laptops that were purchased for your office help you to coordinate with those different offices in the different time zones?
Yes, most definitely. The
And
three hours ahead of us. Saipan is 4 hours behind. So most of the time when you would need to work remotely, be an urgent matter. So if you receive uh, any urgent case prior to our office, you are able to now access it with our laptop.
so before you had those laptops, you and your staff would actually have to drive to the medical referral office, correct? In order to communicate.
Yes, in order to the files needed, we would have to be in on our computers.
And then one of the senators asked about whether you followed the proper excuse me, whether you followed the procurement policies. This reminds me of one of the issues the House alleged that the equipment wasn't properly inventoried. Would you agree with that statement?
Yes, I agree with that.
Explain what you mean, please.
The inventory that was submitted did not have the laptop in it. I myself was not here in Hawaii. I was currently on leave to attend my father's funeral. I did speak to my staff who submitted the inventory list, She told me that she was pressed for time. She had a deadline, and she was here after physically going and logging in what in the that we have in this. That was what was asked from her, was to an inventory of the physical items in our office. At that time, I had my laptop with inside hand. It was after hours, so I'm pretty confident that our patient navigator had his laptop with him. And she said her laptop was in her bag. She just missed it. It basically oversight, made the mistake of not including the.
Okay, so your testimony was a little choppy, so I'm just going to make sure we all understood clearly. You you were required to inventory the items, but you weren't at the office, and your staff mistakenly forgot to include those in that inventory that was submitted to the JGO. Is that correct?
That is a correct summary.
Okay. Were they ever inventoried?
I don't have the answer. I don't have the answer for that
Okay.
one.
But are they still with the office now?
Oh, yes, yes, of course.
Okay. Thank you. Thank you, Mr. President.
Thank you, Counsel, and thank you, Mr. Lefoy. The members don't have any further questions to the witness. If the Counsel don't have any question to the witness can be excused from further participation.
Thank you, Mr. President. Thank you, Mr. Lefoy.
Okay, thank you.
I yield back the mic to you, Counsel, if you have any other statements you want to proceed on.
Yes, Mr. President. I have a summary for this article, this last article 4, and then I also have a closing statement prepared. So if you could just give me a second to get my PowerPoint up.
I'd like to allow for a 5-minute recess, and we'll resume back at 11.
Okay.
Thank you. Okay, we're back into our continuation of a hearing. Before we break, the counsel for the impeached official that asked to further provide some statements, which I'm going to turn the mic over to you.
Thank you, Mr. President. So I just have a summary for Article 4, if I may. Article 4 alleges that Governor Torres unlawfully and fraudulently requested and obtained reimbursements for expenditures, which included multiple electronics, headphones, and computers, items they claim were not properly inventoried or used for a public purpose. But as you have just heard today, that is simply not true. Had the House taken the time to properly investigate their allegations, they would have soon found out that the electronics they claim the governor bought for himself from a Best Buy in Hawaii were actually purchased for the benefit of the medical referral office. As Mr. Lefoifoi just testified, the laptops were purchased so that the medical referral staff could work remotely and better coordinate with offices on Saipan and across the West Coast that are all in different time zones. He also testified as to the Bluetooth headsets, which were purchased for the medical referrals drivers who transport CNMI patients making the stressful travel abroad for medical care to and from their appointments. The electronics that the House alleged were purchased by Governor Torres at a Best Buy for himself were actually purchases that were made for a public purpose and permitted by law. Specifically, they were for the benefit of the Honolulu Medical Referral Office and their staff, so that the staff could do its job more effectively and better serve our community members. And years later, that medical referral office is still using that equipment today. This is all in addition to the fact that once again, the House has failed to provide any supporting evidence for this article of impeachment. And as such, no is once again the only right answer. Thank you. Mr. President, I'm ready to proceed with my closing arguments.
You may proceed.
Thank you.
Counsel, before you begin, recognize or confer with the member. Thank you. Counsel, go ahead. You may proceed.
Thank you. Innocent until proven guilty. The presumption of innocence, which guarantees that any person accused of a wrongdoing in our great Commonwealth is tried fairly, lawfully, and in the interest of justice. Being convicted of a crime is a life-altering experience and beyond redemption for anyone. And so it is in the best interest of our islands and our people that the Senate ensures that any person accused of a crime is not wrongfully convicted. And because a person is innocent until proven guilty, the burden of proof for this impeachment hearing lies solely on the House of Representatives. As prosecutor, the House has the heavy burden of presenting clear and convincing evidence to prove what they alleged in the articles of impeachment. Honorable members of this august body, I respectfully submit that this is something the House has not done and cannot do because it failed to properly make an appearance before you, the Senate, and it failed to submit any evidence in support of any of their articles of impeachment. In fact, the only evidence that is properly before you all go against the articles. Take, for example, Article 1, Theft of Utility Services. As you heard on Friday, CUC Executive Director Camacho testified directly in contradiction to what Article 1 alleges. Director Camacho testified that the governor did not commit theft of utility services, and also that Governor Torres did not have more than one official residence at a time. Did not have his utility benefit paid for more than one official residence at a time. Or take Article 2, which alleges that Governor Torres unlawfully traveled for the purpose of attending a political event. Ms. Glenna Palacios, Governor's senior policy advisor at that time, testified as to the many public purposes of her and Governor's travels in April 2018. First, to pay the respects to the late Bishop Camacho at his ceremonial mass. Next, to meet and tour the facilities of a potential investor in Alaska. And on the way back, they met with Mr. Gary Kuwabara, the Western Regional Director of the Office of Economic Adjustment. And this meeting brought millions of dollars in grants to the CNMI. Article 3, Unlawful First-Class Travel, alleges that the governor intentionally violated the law. However, as Mr. Epifanio Cabrera testified, at the time, most of the government agencies were unaware that premium class travel was prohibited by law. So much so that when Mr. Lawrence Pangilinan, the Attorney General's chief investigator, was instructed to investigate Governor Torres' premium class travel in 2019, he uncovered numerous other officials traveling first class around the same time, including current and former attorney generals, as well as the Lieutenant Governor, Arnold I. Palacios. Article 4 alleges a misuse of government resources. However, as Mr. Lefoy just testified, those electronics that the House used to justify the charges in this article were actually purchased for the benefit of the Honolulu CNMI Medical Referral Office and its staff. Laptops that enabled the medical referral staff to work remotely and deal with the different time zones. Bluetooth headsets that enabled the medical referral office to better communicate with its drivers. That equipment is still being used today at the medical referral office and is still helping to serve our patients as they make the stressful travel abroad for medical care. Article 5 claims that Governor Torres was negligent when he participated in the Deer Meat for Dinner videos. In direct contrast, you heard from Executive Director Priscilla Iacopo of the Marianas Visitors Authority, who testified how Deer Meat for Dinner was one of the MVA's biggest successes because it promoted the CNMI during a time when everyone was indoors, and because it brought over $350 million in ad exposure to the Marianas. And those videos continue to rack up millions of views on YouTube, so that number increases each and every day. In fact, Deer Meat for Dinner was so much of a success that the House presented the House presented a resolution to Deer Meat for Dinner's Robert Arrington to thank him for the work he did promoting our islands. Finally, you just heard from Mr. Ross Garber, a legal expert in the field of political investigations and impeachment. He discussed how the contempt charge in Article 6 was legally defective because the JGO committee's subpoena violated the separation and balance of powers of the Constitution, as well as CNMI statutes. Mr. Garber also explained how the governor responded reasonably to the subpoena and how non-compliance with the subpoena does not rise to an impeachable offense. Each piece of these evidence raises more and more questions about the articles of impeachment. And instead of showing up to defend against these discrepancies, the House made the conscious choice not to file an appearance here in the Senate. Just like they made the conscious choice not to file an impeachment record. And how they chose to cherry pick facts to support their articles of impeachment. Let's be clear, it's because of all of their choices that it is now impossible for them to meet their burden of proof today. And they have no one else to blame but themselves. Honorable senators, I hate to beat a dead horse here, but this impeachment has been a failure from start to finish. First, the House failed to comply with the House rules when it investigated and impeached Governor Torres. At the same time, the House failed to comply with the Commonwealth's ethic laws because Tina Sablan was allowed to participate and vote on the impeachment of her biggest opponent this coming election, despite her apparent personal and financial conflicts of interest. The House also failed to comply with the Commonwealth Constitution because the articles of impeachment contain 6 unconstitutional penalties. And then the House failed to comply with the Senate rules simply because it did not agree with them. And as we just discussed, the House failed to meet its burden today of proving each article of impeachment by clear and convincing evidence. Because it chose not to properly enter an appearance, and it chose not to file any supporting evidence. And no matter what anyone says about this hearing in the next interview, on the news, or during the next public comment, which, by the way, are not made under penalty of perjury or subject to cross-examination, it is undeniable that the House has failed to meet its burden of proof here. As lawmakers, you must all agree that everyone should have an utmost respect for the law and the legislative process, regardless of political party. And as gatekeepers of the impeachment process, a vote against the articles of impeachment today sends the proper message to the entire Commonwealth that if the House is ever going to try and undo the will of 62% of our people, then it must do so in strict compliance with the law. Does clear and convincing evidence exist to sustain each article of impeachment against Governor Torres, to remove him from office? Honorable members, I respectfully submit that the only fair and just answer you could give today is no. Thank you for your time and attention.
Thank you, Council. I also want to thank the everyone for participating today and joining us this morning. Members, thank you for being here this morning. That concludes the hearing on the 6 articles. Also allowing the members to pose their questions to the presentation this morning and the presentation on Friday. So at this time, the chair moves to item number 5 of our agenda, under public comments, of which the 5-minute rule is hereby invoked. And I ask that we stay within the context of the order of business that we adopted on Friday that carries on to today. And the process is that when you go up there to offer your statement, you state your name for the record. So at this time, public comments is now open.
Mr. President, before we proceed to public comments, would you like us to stay in the well or?
Yeah, I apologize. You may
Okay.
be excused.
Thank you.
Yeah, hang on a second, Sarge. Let them clear the. Let the councils clear the. Then you can begin. Please proceed, sir, and I apologize for the short delay. Please proceed.
Half a day and zero. Greetings, distinguished senators. My name is Wendell Mary Posadas. I'm here to provide public testimony on the matters relative to the articles of impeachment. I'm here to encourage the Senate to vote no on the articles of impeachment. I'd like to begin by sharing with you, the listening audience, that I am a father, husband, tax-paying residents, and active members of our community. I'm involved with several civic organizations and volunteer my time freely because I love this island. It is my home. I share it with you and my wonderful family for the span of 31 years. For those who know me, I'm not involved in any politics. This is the first time I'm asserted myself vocally and publicly. What we're going through with these articles of impeachment has divided us. It has hurt our image to the rest of the world. Worse, it has damaged personal relationship. At first, I was curious about what it was that Governor Torres was accused of doing wrong. Then those hearings passed only to surface again. Years later, we have a chance to listen to both sides of the story, most recently, and clear the governor's side. It is my opinion, and now the public has the chance to weigh the evidence for themselves. I have had the privilege to listen to the arguments in defense of the Governor Torres and supported by the evidence provided by his legal team. More so, what I learned in this an impeachable offense is something that a majority of people decide to be impeachable offense. It, it matters how we can best work and best agree for the betterment of the CNMI. The House of Representatives impeached Governor Torres, one of more accounts for something that did not break the law. He was, in my opinion, impeached because the House had a different policy position or interpretation of the facts that the governor. And these, in my opinion, are not impeachable offenses. I am referring to the social media promotion and utility benefits afforded to all the governors and lieutenant governors. I don't intend to go into the detail with the articles. I just wanted to share my observations. I would like to choose by sharing this. Recently, I have come to know the Governor Torres, and I believe has been a God sent to our community. He is a humble family man. He is a generous soul, and he is approachable, easy to get along with. And if you had the privilege to spend time with him or serve him, Governor Torres is a man of the people. He has tremendous support of various community and Commonwealth civic organizations. Senators, I'm asking that you please vote no on each of the articles of impeachment, and I'm praying that we put this behind us and begin the healing process of building up our community. Thank you.
Sir, please repeat your name again.
I'm Wendell Mary Posadas.
Okay, thank you. The next individual that would wish to offer public comments.
Good morning, Mr. President and members. My name is Maria Fricati Pangilinan. Today, I'm a concerned constituent to comment on House Resolution number 22-14, impeaching the governor for the commission of felonies, corruption, and neglect of duty in violation of Article 3, Section 19 of the CNMI Constitution. Article 1, commission of felony, theft of utility services. CUC was established as a public corporation by the CNMI legislature to provide water, power, and sewer services. CUC was also designated the responsibility to establish rates and meter bills and collect fees in a fair and rational manner from all customers of utility services. These services also apply to the governor's account under the taxpayer-funded benefit for his residents. All account holders go to CUC to dispute billings, especially excess billings for water. It is not unique to the governor's account only. CUC will receive the complaint and go through a process to address and settle the dispute. CUC fixed the governor's disputed charges in the same manner as all other account holders. The executive director testified that they follow the same process in adjusting the disputed amount as other customers. There is no reason for the legislature to intervene and dispute the decision made by CUC, as they had given away their power to CUC when they created the CUC as an independent public corporation. Does this mean that the public should now go to the legislature, JGO committee for any disputed billings from CUC to determine whether they should be convicted or not? Of course not. Therefore, the governor should be free and dismissed from the theft of utility services as resolved by CUC. Article 2, commission of felony, theft, counts 1 to 4. The public auditor addressed the issues of travels in the letter of August 18, 2020, referencing Public Law 15-86 of September 26, 2007. After Public Law 15-86, Public Law 20-87 was enacted on February 5, 2019. Specifically, for NMC, Northern Marianas Housing Corporation, and Commonwealth Development Authority, CDA, now CEDA, not to fall under Public Law 15-86. OPA, in its audit report, pointed out that to minimize the confusion and inconsistencies throughout the CNMI government and avoid legal disputes, it is necessary that the legislature resolve any conflicts within the law over official government travel, and further recommended that the legislature review current travel laws and address any conflicts over official government travel. The governor appoints and relies on employees to assume day-to-day management responsibility. Counts 1 to 4 went through the review process by employees of the Finance and Accounting Department. It should not be a cost to pick, or as the legal counsel of the governor say, to cherry pick only on the governor for conviction, when the overall issue of travel points to both the executive branch and the legislature to correct the mismanagement, inappropriate actions, and inadequate oversight. The public should also find it interesting that the Speaker of the House justify why the Northern Marianas Housing Corporation and CEDA fell under a different law when the public auditor recommended a uniform law to apply to all government agencies. The Speaker justified that Northern Marianas Housing Corporation and CDA will be paying with federal funds. Hear that. Senator Hokuk, then Senate President, should be commended for proposing draft legislation to provide one policy covering all agencies and repeating the special law for Northern Marianas Housing Corporation and CDA law. And Senator Hokuk did not consult with me. I found this letter under the auditor's report. The governor always carries his title as a governor, whether he attends fandango, bautismo, entertainment guests, or attends gatherings within or without CNMI. The people he meets, whether Democrats or Republicans, away from the CNMI or within the CNMI, honor and respect him as governor. Our governor conducts himself as a governor 24 hours a day, whether he goes to the Northern Mariana Islands, Guam, Rota, or the United States mainland. I'm not aware of any job description for the governor because he operates 24 hours.
Okay, Ms.
The first-
Pangilinan,
yes,
Ms. Mesa, but your
just-
time is
Okay,
about to.
the First Lady attends to the public in her governor. I'm just want to show that there are many potential pitfalls in government policy and enforcement, and the legislature should work to solve a mutual problem from a broader perspective of tightening the policies and regulation to prevent pitfalls and conviction. The legislature working as a problem solver should work as a problem solver across partisan lines, can resolve these administrative issues to ensure that laws apply equally to all government agencies. Everyone is aware that the people in charge of enforcement need to be trained and understand the rules. The conclusion of the impeachment hearing and the decision of this Senate body is the most critical political decision you will make that would affect the families of the governor and the people of the CNMI. The governor does not deserve this denigration. All accusations should be dismissed to be resolved appropriately by the administrative action in compliance with the public auditor recommendation, the right agency to follow up for compliance and help current mismanagement, inappropriate actions, and inadequate oversight. Thank you, Mr. President. Even though I have more details, but
Thank you.
thank
I
you
apologize
I
that
will
we have
comply.
to.
I do appreciate it.
Can you please, Ms. Pangilinan, if you don't mind, can you please submit it for our records? Thank you so much. And the floor is still open, and state your name for the record, and kindly please stay within the 5 minutes as much as possible. Okay, thank you.
Good morning and magandang umaga po sa inyong lahat. My name is Irene Hall and I am a longtime resident of the CNMI, over 25 years here. This is my home. I have seen and worked with many governors in the past and elected officials over the years, but I took time today to share my thoughts about Governor Torres and his contribution to our community. He has done so much for my community, my kababayans. He has helped so much. He has done so much for the guest workers. He has done so much for hundreds of families over the years. If anyone is capable of leading us to rebuild our homes and our community, in my heart, I know it is Governor Torres. I am providing testimony as to the character of our governor. I am humbly asking you to please vote no. Let us keep Ralph Torres as our governor. Let us allow the people to decide in November. So thank you very much. Yun lang po. Maraming salamat po. Salamat.
Thank you, Ms. Ho. The floor is still open for a member of the public to provide testimony, and state your name for the record, and try and we contain within the 5 minutes. Thank
Good
you.
morning and buenos dias, senators. Thank you so much for having public comments, although it would have been nice to have them at the beginning, but I do appreciate that we have this opportunity. My name is Leila Favea Fleming Staffler. I am a member of the House of Representatives and I represent Precinct 5. Notwithstanding the presiding hearing officer's assertion this morning that the Senate has consistently followed its own rules, it has in fact repeatedly and egregiously flouted them. To cite just a few representative examples, Rule 19 provides that any motion to dismiss must be submitted in writing to the presiding officer within 14 calendar days prior to the day set for the commencement of the hearing of the articles of impeachment, or as permitted by resolution adopted by the Senate. The day set for the commencement of the hearing was May 13th on Friday. The window to file was from April 29th to May 13th. Council Uggan filed his motion on March 28th, fully 32 days outside of the window to file. No resolution was adopted to permit a motion filed outside of the time window to be considered. The motion was therefore time barred and therefore not properly before the Senate. The presiding officer concocted a requirement with no basis in the rules for senators to submit their questions in writing.
Ms. Fleming
Yes, sir.
Staffler, please stick with the agenda. You're veering off. So please stick with the agenda that we have before us today. Thank you.
Basically, what we need to go over and just realize is that the rules that guide this case were not really followed the way that they have been claimed to. The evidence that was not presented basically was because there was no opportunity to present it. And if only the Senate had given us that opportunity. All of the evidence that has been shared in the last days of these last few days are not really fully complete without House prosecutors. And so with that, we want to just make sure that people realize there is more to this case than what is presented to the members today. Thank you.
Jesus Masi, thank you for your participation this morning. The floor is open for any member of the public to offer remarks or comments on the order of business on today's hearing. Again, I couldn't overemphasize the message, the order of business before us today. Thank you.
Good morning, senators and members of the public. My name is Tina Sablan. I'm a member of the House. Governor Ralph Torres is supposed to be on trial in the Senate. He has been charged by the House of Representatives with 6 articles of impeachment for theft, corruption, and neglect of duty. And the Senate has a solemn obligation to deliver due process and a fair trial. But what began last Friday and what continued today is not a trial at all. There were no prosecutors because the Senate leadership rejected the team of House prosecutors appointed by the Speaker. There was no evidence because the Senate leadership rejected the entire House impeachment record. The Senate only heard one side in this proceeding, the governor's, through his defense counsel. The governor's attorneys say it is the House's burden to prove the impeachment charges, and that's true. But what is also true is that the House's hands have been unjustly tied by Senate rules that were drafted by the governor's counsel in collusion with the governor's allies in the Senate. This is not a trial. This is a travesty of justice. Because there were no prosecutors, there was no cross-examination of any of the governor's witnesses, there were no House objections to the procedural violations, no rebuttals to the misinformation presented by the defense. The senators themselves were deprived of their right to freely ask questions of the witnesses because the Senate president compelled them to put all their questions in writing to him and him alone. And then he screened their questions, censored some of them, and restricted follow-ups. Nothing in the Senate rules requires the senators to reduce all their questions in writing, but forcing them to do so anyway achieves the goal of frustrating any attempts by any senator to get to the truth. The governor's counsel, on the other hand, had no such restrictions. If the Senate had allowed the House to fully and fairly participate in this trial, with all the evidence we have to back each and every article of impeachment, you, the Senate, and the people we serve would have had the opportunity to hear both sides. You would have had the opportunity to get to the truth. To my fellow citizens of the Commonwealth, this mockery of a trial will end soon enough. The verdict is already known. Truth and justice will not come from the Senate, but it may come through other means. Senator Paul, Manglonia, and 2 other taxpayers have sued the Senate. The Attorney General has filed criminal charges against Governor Torres. Perhaps there is more to come, but one thing is clear. Our quest for justice and accountability will not end with the Senate. A final note on Mr. Garber and his participation in this proceeding. Mr. Garber was not sworn in as a witness, nor was he on the witness list, but he appears to have testified to matters of fact regarding the factual basis of Article 6 of the Articles of Impeachment. He is admitted pro hoc vice to the CNMI bar for the limited and sole purpose of representing Governor Torres in his civil suit against the JGO committee, and he appeared as counsel today in violation of the terms of that pro hoc vice admission. Insultingly to our Commonwealth and sanctionably in court, he provided no citation whatsoever either to the CNMI Constitution or to any CNMI case law to support his assertions drawn from federal context regarding the separation of powers. He knowingly misrepresented the facts of a case in which he himself appeared as counsel. In the Connecticut case he mentioned, the Connecticut House Committee was prepared to enforce its subpoena via an article of impeachment, just like Article 6 of the present articles, as opposed to criminal prosecution, which it disclaimed. A formal referral from the Speaker is indeed a referral from the full House, as Mr. Garber knows perfectly well. Contrary to his assertion, Governor Torres does have a specific statutory duty under Commonwealth law to comply with legislative investigations, specifically 1 CMC Section 1308, which provides that the officers and employees of the Commonwealth shall cooperate with any investigating committee and with its representatives and furnish to it or to its representatives.
Ms. Sablan, your time is about.
I am concluding. This is the last sentence.
Thank you.
Such information as may be called for in connection with the research activities of the committee. Governor Torres neglected the statutory duty, which is indeed an enumerated constitutional ground for impeachment. Thank you.
Thank you, Representative Sablan. And the floor is still open. And kindly please state your name for the record. And again, I'll be reminding you once you go off your time limit. Thank you, Mr. Mosse.
Good morning to all Upper House, Honorable Upper House Senators here in attendance today. My name is Raymond Bora Kirwa, a native son of the Maranas. I come to you today to address the legitimacy of the law of the land that has directed this government since the inauguration and birth of the CNMI. I am dumbfounded to hear facts and testimony of Mr. Camacho, Mr. Pangilinan, and Mr. Cabrera, and the allegations being stacked up against Governor Torres. If I may, just to go back with a previous podcast that I aired out, that the JGO messed up since the beginning of the investigation. Why I say this? It's because all their unfounded evidence has not yielded any substance to their allegations. So I ask you this today. Will you weigh the evidence and testimony without any reservation and uphold the law to the merits of the language that it was written? I'm not politicizing or campaigning here today, but I want to express my grievance about the JGO chairwoman that even she, who was citing our local laws, was at the same time condoning a federal mandate about cockfighting that was taking place next to her home.
Sir,
Now,
please stay within the context
All right.
of the agenda.
Now, I ask you this, is that acceptable? I say no. In closing, I want to thank this body for giving me this opportunity to air my concerns. Thank you, Zan Memorias.
Thank you, Mr. Kirwa. And you may, if you wish, you may submit your comment to the Sergeant at Arms for our records. Thank you so much for your participation. You may proceed. State your name for the record and please adhere to the 5 minutes.
Si Pablo, familian Teting, Dilong Guerrero. Otuzu Pogu pa be jamma I attention minzo. Za pwede un ekungu kofa pa be songen Pogu. Lo todo esti ni makikit sogi o chupatira. Gagi bondan pura bondan sinagli jan bondan tinay bira. Sofana ti sinema patikilay ni Parumalegre esti masasangan nagwa bidone gobyerno ni Latsi. Pres jangin matsogi no nay mapatike no nalay. Oji anesta manoja ni gobyerno za offer legnia yo chupatira na tizania parumali pat matsogi distipogo para mona eno paron taka janggaluti janilay. Tisina unggaluti lay ja ipamalu machotsogi sa gagi no gibondan cultural governance mapatitika no Sa hamzu man mogas, hamzu sempi debi dita dai na maulik todu ina na mizu kareran mizu arofa pun sogi pun fatso pare tau ta janita nota. O gagagaw hamzu ni man senadora jan senador por favor fan na pora esti ofa i ma sucesseri sa latsi. Untung ofa kumekele kuno. Hasui reason of doubt, no? Lokwi na sabihin no. Sa ofa i masasangan, esta impotsuzu za osunu pa be hungu za be ekung ofa makikitsogi. Latsi. An paro matsogi no tagilag na ji unu na Palawan. Debiru ma legra no za gilay. Loti matsotsogi no chubia. Tisina para i gobernu paro dododa to dudu esti ni agas matsotsogi gini gi gubernota. Pres Augustino pun hasu todudu esti ofa ileleku amzu lokui genoni man mogas por favor fan hasu munga perun sogisti presun zame kesti ikut torota iningeta ti manggaiam gohon pad i storu sinirus ni tagini esti na klosi ni manggaganzi. Pres por favor fan Munga mapunu esti jota culture governance sa bonito za mangi za be siga be gagi gini za be prote za be adai mona. Anamzu loki pun hono mono na siguro na gwagi menmu na ni manenging jan mames za bonito si jan mizu ni perun zofai gwatu pun mimuji pa ofa tanisita pa esti tanota jani tau ta. Sizus mosi. Adios.
Jesus Mosi, Mr. Pablo. The floor is still open for any member of the public to offer comments reference to today's order of business. Today's order of business, today item. And state your name for the record.
Buenas dan good morning para todos andun ni membro ni chamber, senators, Guahu si Geraldine Demapan Sebaklim. Tumotogi zo pago ginigi menan mizo para bitis tuguji igubetno dani enterimenti ni tau-tau tano na tsegi po favor imaulik na tsotso sa todo do pago giiningok ko ni testimonyo nesti siya na witness imang testimony man testify mala sabi sanganian so todo do ni senador parewa loki jan todo isem papa naguman ni mani ikungupago gini na ogan na tujuti tempo ko para before tumagi sabi infot mamjo na impausas din na aktui impeachment sa tada balinya za ogogogo amzo na ina amzo kurason mizo para itaw tono sa kumugwahu uno na empleo ilestrutura uli daw tistigujit todo di kandidatuta ni mamailihi alon finatsutu niya. Senators, bula pabisangan sa 5 minutos sa manayo. Lobi utur ipalabra dani mensahe ni pabidogo udon sa gwahalo kichito chogi sa nizon para itaw tano. Datajo gogogo amjo na si Zeus maasi lisensya mizo lisensya ni Marianas taw tano then defendi itaw tano sa tajas dinagubetno uli babang bedanya entry mas taja ni matsigo kumuhuno na empleo niya zo ja atago zo pabihudon za befana juda taja niyo ha umano zo faisingin ni sila republiko za paro aluk taja patisinya esti pago na aktui paro mapausa jahon and bota ahi Gipino Americano, por favor, do not vote yes. I ask you guys to please look upon our people. because all the works that the governor has done, he has been doing so well. And I've been to the state side, and I did hear the people, and I promised them that when I come back home, I will make sure that the governor will not be taken out of his office. Todos di siya pago na to impeachment ni ma-introduce si pago, puros di siya embitigo. The malabi na tungan to senators na testigit tano malago niya. Sani man may lihiyam to halom, perentegi itetso mizo ni malago mami. Dan hafa in spekpekta gizahamzo. Pes estia, guamas pabisangan lo polo dabi utut. Sa timunan na janjo, jabe na yamjo, ni bendisyon ni Saina, na idesisyon ni Fatinas, idesisyon para imaulik interimenti ni Toto Marianas. Si Diyos Masi. Thank you.
Si Diyos Masi, Ms. Beckling. Piso mababa para public comments, and again we asked the individual to please stay in the context of today's agenda and state your name for the record and abide with the 5-minute rule.
Buenos
Thank you.
dias, Senate President Jude Hoff-Snyder, Senate members, Guahu si Dolores Regis Drew, gay gitu pago gini gimenan mido para veo testigo por este impeachment ni gobyerno. Malago din ang kumprendi na timantangay tao-tao dan timambatsit. Todo do hafa man mansangan gidistitutuhon gi Betnis May 13 gi Betnis man manungok to di tao-tao. Interamenti Amerika dan todo lugar ni man manungok itao-tao afa man masusesedi. Esta maplanta todo afa man masangan ni abogado. Esta todo debe din kumprendi afa sta man mansangan. Tinisisari patasigain meripiti apa patasangan. Lo debe ditag kumprendi na todo yung ebidensya ni man mapresenta, pareho ay man testigo, esta monadan todo man tali na igobierno tada afay saunya galumesti, sigun gi afa siya man mapresenta. Tada masusedi gi gobierno afa bidanya. Tada mas malago olo ki pataatan. Sa mampus matatakay gobyerno. Dahil ebidensya to din man anuk, timan tangahi dan timan batsidit beripiti talo. Na tada afa bidanya. Pus malago dun ang kumprendi. Na debi dita ibaluan mais sa pago na ani. Urispetam do todo senador. Dan hindi manaigi ni tres pago na ogan. Na danggin mane kung kanjo na tres na senador. Dan ni House of Representatives. Todi 5 na membro ni JGO. Por favor, atan maulik zon ibaluan maulik hafa inchegbi nesti gobyerno sa tibunito afa bidan mizo. Tibunito por favor afa bidan mizo. Ang pabiatan nesti sinat i 5 na JDO gi kongreso. 32 mil gi sakaning gagana. Galimi 2 años na parempatasungi 64 mil ing gagana. Galimi 2 años. Gieno na tempin mizo ang paranatan. Taja afa minaulik bidan mizo ni kongreso. Pus por favor na parasti. Za insigi mo na chetsumizo. Para minaulik iteramenti tau-tau sa tipempino y 2 años para este na investigasyon ni taja sustansyannya. Haswa nagi kada 32 mil ing gagana. Gi 2 años 64 mil ing gagana kongreso.
Mr. Drew, por favor, no stick with the agenda. Thank you.
Malago na pero kumprendi na na mampus dang kulo na sa lapi taxpayers money ginin namin ni tauto inapapasyam jo da para impino 2 años gitada sustansya niya dang kulo na sa lapi lokwi da tada sustansya hafa na minaulik na revenue in chegi para hamin ni tauto tanu tada pura investigasyon in chegwi lo mungi hafa investigasyon in chegwi hafa sustansya niya tada hafa bidanya gobyerno nanon atan tinisisari be balua mas muna sa stantinga todo di afa man mapresenta di Bernis an mane ekung kanjo. Ugagagoloki na mala data na poras ti. Data fan positive mo na. Then na chansay gubernota. Johono jo tutun fuma tutuit gigijahan na maisa sa gijahan na maisa pag gipresente kalalamtin afa tututuit tau di tauto. Animoso na tauto. Mala data fokus talo mo na gi istima mala na 4 años para minaulik interamenti tauto. Ta fokusit data nasuai gi bandan negrif data fan ano mona ta nasuai gi fiuni politics dan official na distraction data fan ano ta mona data tendi tau ta say tau ta mona fan mata sungit itau ta mona fan mata sungit. So let's focus on the people. Tatutun mona si chota data na fan punadan afa patasogi para minauli ki tau data fan mamatinas revenue para interamenti tau no tana paras ti siasta tana para data bota no para i governo da mga na uma kondena ni toda hafa bidanya. Pesbesanga na didig finu Amerikano dangin di siya naman hobin ti kumun pependi. Let's focus on what the next 4 years is going to bring us and how the life of the people are going to be improved. Let's just focus away from negativity, away from politics, and away from distraction, and back on the people. Let's focus on the people. Da tana para stasti impeachment, tana para pagunani ugagawam du fabot angin audio me kungugdo kongreso pat kongreso senadoro pan masya audio galum estiangayo por favor mala da tabota munga no sa toda fa malabidanya.
Your time is up.
Si dus masi pada masuk agawam du dangkulo na si dus masi na fan matging korason mido angin audio mane ekunguk then bota maulik para gobyerno por favor ugagawam du talo pagunani.
Thank you, Ms. Drew. The floor is still open for any member of the public to offer their comments with regards to the order of business for today. State your name for the record and kindly stay within the confines of, or stay within 5 minutes. Thank you.
Afade, Tiros, and good morning. For the record, my name is Giselio Taimanyo Ogo. I was born on Rhoda and raised on Saipan. I'm here to respectfully ask for the CNMI Senate to vote no on each of the articles of impeachment. Without getting into details of these hearings, I want to share my thoughts on why you should vote against the articles. You should vote no on the articles because, simply put, it's legally flawed. We all have heard witnesses testify, evidence submitted in this chamber. All of these evidence directly proved that Governor Torres did not violate any laws as the JGO claimed. Now, I am by no means an expert of the law or a lawyer, but everything I've heard points in that direction. For example, the fact is that Gary Camacho, CUC's executive director, testified that the JGO presented him with a fabricated document not made by the CUC. This document was used by the JGO. They knowingly used such document that was fabricated to impeach Governor Torres. This is their tactics as a whole. However, I am happy that we, the people, finally know the truth as we deserve. These are not rumors or conjectures. These are facts supported by evidence. Another, the online promotion of an adventure series of videos by a world-recognized adventurer broke no laws, but because it was broke from the norm of how one group prefers to promote the Commonwealth, Poma-impeachay governor. I humbly ask that you vote no on the articles because the accusers themselves chose to overlook the same alleged offenses caused by the people who are a part of their concerted effort to attack the governor ahead of this November election. Last, I would like to share that I've known Governor Torres since I was a child. I've grown up watching the governor himself learn and grow in his leadership roles. Leadership roles like House of Rep, a senator, a Senate president, lieutenant governor, and a governor today. I watched him grow in fatherhood with 6 kids. Each time I was there to witness him speaking Chamorro to his children. supporting his wife, and I am still grateful to this day to have the privilege to watch this role model of mine lead his family and community. He isn't perfect, and no one is. I am not, and definitely no one in this chamber is either. But what I can tell you, what I can testify today is this. He is a man of principle, a family man. Ralph de Longueuil Torres is a God-fearing man, and as you all have seen, long-suffering. In closing, and from my personal experience as a young entrepreneur, even a former law enforcement officer, it does not matter how well you do, how good your intentions are, if your enemies want to take you out. If they look at you with hate or envy, then nothing will appear right in their eyes. With that said, despite the House's relentless attacks on Governor, there's a saying that I would like to close with. The saying is that something that after watching a sworn testimony of expert witnesses about the targeted investigation of Governor Torres and not others, the saying couldn't be more befitting. Mas saddik un gatsa idakun kini ikezaw. Thank you for the opportunity to have the people hear the Governor Torres' side of the story. The lack of the clear and convincing evidence, in addition to not meeting the burden of proof necessary to impeach and remove a sitting governor, is more than enough to vote no. With that said, I want to say thank you, Ton Ogun, for sharing the truth that the House did not give Governor Torres an impartial chance, and the witnesses for pinpointing out the truth. Thank you, and God bless you to every single senator here for allowing me this time, or at least to those of you who have the dignity and respect to face the issue head on and stayed in your seat to see this through. And also allow us your honorable time as we, the people, give our public comment. This is a pivotal point in our time as a Commonwealth. And so I thank you for giving us that respect and not allowing childish tendencies to get in the way of your duties. Thank you for giving the governor a chance to tell his side. And while we're on the subject, thank you for giving also the lower house leadership the opportunity to present their case, even though they chose to leave their supporters in the wind and not show.
Mr. Ogo, your time is up, so please.
So can I have just a few minutes, sir?
5 minutes
Okay.
applies. So if you can sum
Just
it
wrap
up.
it up.
Thank you.
It is unfortunate that the hype was bigger than the game. After 2 years of hype and foreplay, and without surprise, they failed to satisfy. Instead, they chose to sit on the sidelines. Public comment. Please vote no to this, and let's move on together in building a great Maranas. Because Tazagini negative, and it's all positive vibes. Thank you.
Jesus Masi, Mr. Ogo. Again, the floor is still open. Continue with the public comments. Being nothing further, public comment is now closed. Thank you all for providing your comments to the hearing this morning. And thank everyone for your participation in one way or another, whether you are here with us physically or somewhere else in the building or virtual participation. Truly, however you look at it, we did provide this form to inform the public of the proceedings since the onset of this issue before the legislature. So with that, I recognize, unless any of the members would like to offer some comments before we entertain a motion to adjourn. Ready? I recognize Senator Carl to offer a motion to adjourn this articles of impeachment hearing.
Thank you, Mr. President. I now officially like to offer a motion for the adjournment of today's Senate hearing on the articles of impeachment, subject to the call of the chair. So move.
Motion for call for adjournment, subject to the call. Under discussion, I will be notifying the public and the members of the Senate on the session to entertain the votes on House Resolution number 22-14. And it's going to be happening very soon. So again, thank you very much for your participation. I wish you all good day and stay safe. This hearing stands adjourned, subject to the call.